Obligations and Contract, Chapter 4, Extinguishment of Obligations, General Provisions, Article 1231. Obligations are extinguished: 1. By payment or performance. 2. By the loss of the thing due. 3. By the condonation or remission of the debt. 4. By the confusion or merger of the rights of the creditor and debtor. 5. By compensation. 6. By novation. Other causes of extinguishment of obligations such as annulment, rescission, fulfillment of resolutory condition, and prescription are governed elsewhere in this code. Section 1. Payment or performance. Article 1232. Payment means not only the delivery of the money, but also the performance in any other manner of an obligation. Article 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to that debtor. Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Article 1238. Payment made by a third person who does not intend to reimburse by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Article 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid without prejudice to the provisions of Article 1427 under title on natural obligations. Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. 1. If after the payment, the third person acquires the creditor's right. 2. If the creditor ratifies the payment to the third person. 3. If the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. Article 1242. Payment made in good faith to any person in possession of the credit shall, shall release the debtor. Article 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall be valid. Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obliger's will. Article 1245. Dation in payment whereby property is alienated to the creditor in satisfaction of a debt in money shall be governed by the law on sales. Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestation in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Article 1249. The payment of the debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which the legal tender in the Philippines. The delivery of promissory notes payable to order or bill of exchange or other mercantile documents shall produce the effect of payment only when they have been cash or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in abeyance. Article 1250. In case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment unless there is an agreement to the contrary. Article 1251. Payment shall be made in the place designated in the obligation, there being no express stipulation, and if the undertaking is to deliver a determinate thing, the payment shall be made when wherever the thing might be at the moment the obligation was constituted. In any other case, the place of payment shall be the domicile of the debtor. If the debtor changes his domicile in bad faith or after he has incurred in delay, the additional expenses shall be borne by him. These provisions are without prejudice to venue under the rules of court. Subsection 1's application of payments. Article 1252. He who has various debts of the same kind in favor of one and the same creditor may declare at the time of making the payment to which of them the same must be applied, unless the parties so stipulated or when the application of payment is made by the party for whose benefit the term has been constituted, application shall not be made as to debt which are not yet due. If the debtor accepts from the creditor a receipt in which the application of the payment is made. The former cannot complain of the same unless there is a cause for invalidating the contract. Article 1253. If the debt produces interest, payment of the principal shall not be deemed to have been made until the interest have been covered. Article 1254. When the payment cannot be applied in accordance with the preceding rules, or if application be inferred from other circumstances, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. If the debt due are the same nature and burden, the payment shall be applied to all of them proportionately. Subsection 2, Payment by Concession. Article 1255. The debtor may cede or assign his property to his creditors in payment of his debts. This cession, unless there is a stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned. The agreement which, on the effect of the cession, are made between the creditor and his creditors shall be governed by special laws. Subsection 3, Tender of Payment and Consignation. Article 1256. If the creditor to whom tender of payment has been made refuses without cause to accept it, the debtor shall be released from responsibility by the cognation of the thing or sum due. Cognation alone shall produce the same effect in the following cases. 1. When the creditor is absent or unknown and or does not appear at the place of payment. 2. When he is incapacitated to receive the payment at the time it is due. 3. When, without just cause, he refuses to give a receipt. 4. When two or more persons claim the same right to collect. 5. When the title of the obligation has been lost. Article 1257. In order that the consignation of the thing due may release the obligor, it must first be announced to the person interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. Article 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved, in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or sum deposited, allowing the obligation to remain in force. Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released.